Consider two couples who have been together for 30 years. Both have raised children, shared bank accounts, and participated in ceremonies they believed bound them in law. Now, both couples are separating. The first couple proceeds through the courts. Under the Matrimonial Causes Act 1973, a judge formally dissolves their union, equitably dividing their shared property, splitting pensions, and ordering ongoing financial support. The second couple enters the exact same court system. The judge reviews their case and refuses to grant a single financial order. The financially weaker partner walks away with absolutely nothing. Both couples made a commitment in front of witnesses. Both lived as spouses. Yet the legal system evaluates the second ceremony and concludes that no marriage ever took place. Subjective belief in a marriage offers zero legal protection. If specific statutory procedures are ignored, the financial safeguards of a valid union evaporate. For any ceremony conducted outside the Church of England, legal validity rests on strict compliance with statutory civil preliminaries. Failure in these preliminaries may result in a void marriage. This describes a union that is legally flawed, yet still enables the parties to access statutory financial remedies upon its dissolution. A more severe failure leads to a non-qualifying ceremony, or non-marriage. This type of union is so procedurally defective that it strips parties of all statutory financial protection. To understand these outcomes, we must dissect the timeline of civil preliminaries and locate the boundary where a flawed void marriage devolves into a legally meaningless non-marriage. Investigating these preliminary steps is a family lawyer's primary duty. They dictate the availability of all future financial relief for the client. The mandatory first step for all civil and non-Anglican religious ceremonies is a formal declaration of the intention to marry. Both parties must appear in person at the district registry office, where they reside, to give a notice of marriage. Under this system, a marriage cannot legally take place until 28 full days have passed after the notice is given. This notice is valid for a maximum of 12 months. The ceremony must occur within this specific window, or the process must begin again. Church of England weddings generally bypass this specific civil process, relying instead on the separate publication of banns. Missing the 28-day window or overstepping the 12-month deadline breaks the required legal chain before the ceremony even begins. The process changes when one or both parties are non-EEA nationals with limited or no immigration status in the UK. These cases are referred to the Marriage Referral and Assessment Unit, or MRAU. The notice file is automatically routed from the local registry to the central MRAU to investigate potential abuses of immigration law through sham marriages. An investigation by this unit significantly alters the couple's procedural timeline. The mandatory waiting period increases from 28 days to 70 days, visibly reducing the remaining window for the ceremony to occur before the notice expires. Attempting to abuse immigration laws through marriage can lead to prosecution, deportation, and a 14-year ban from re-entering the UK. These preliminaries transform giving notice into an enforcement mechanism for state immigration policy. Once the notice period concludes, the couple may proceed to the ceremony, where strict structural requirements still apply. A civil ceremony must occur on approved premises, be open to the public, and requires 2 witnesses along with a registrar. Non-Anglican religious ceremonies must take place in a building specifically registered for religious worship and the solemnization of marriages. While Quaker and Jewish weddings follow their own internal rules for the ceremony, they are still required to complete the initial civil preliminaries. Regardless of faith, the state dictates the minimum structural elements required for legal recognition and tracking. In practice, ceremonies often suffer from defects, such as occurring in an unlicensed venue or after a notice has expired. Under Section 49 of the Marriage Act 1949, these defects only invalidate the marriage if the parties knowingly and willfully disregarded the rules. A void marriage sits in the center of this spectrum. Significant defects exist, but the ceremony sufficiently resembled a legal marriage under the relevant acts. In Assad v. Kurder, the parties underwent a ceremony in a Syriac Orthodox church that failed Syrian notice and registration requirements. The judge ruled the ceremony was not so deficient as to be nothing. The court declared the union void. A void classification allows parties to apply for a formal nullity order from the court. This nullity order provides the legal basis for financial remedies under the Matrimonial Causes Act 1973. At the far right of the spectrum sits the non-qualifying ceremony, or non-marriage. It is entirely disconnected from this protective framework. These ceremonies are so fundamentally flawed and devoid of statutory compliance that they cannot be considered even void marriages. The case of Akhtar v. Khan involved an Islamic nikah ceremony. Despite an 18-year relationship and 4 children, there was no civil notice, no certificate, and no registrar present. The court ruled it a non-qualifying ceremony. In Al-Gamal v. Al-Maktoum, the parties held a secret ceremony in a London flat. The wholesale failure to comply with English formal requirements resulted in the nullity application being dismissed entirely at the Royal Courts of Justice. Because no nullity order can be granted for a non-marriage, the parties have zero access to statutory property and financial remedies. Sincerity of intent and length of relationship cannot mitigate a total failure of statutory procedure. The law treats the union as if it never existed. There is a widespread assumption that long-term relationships eventually grant legal rights to the partners automatically. The common law spouse is a myth. The concept does not exist in English law. Couples in a non-marriage are treated strictly as cohabitants. Property disputes between cohabitants are settled by strict property and trust principles, rather than the fair distribution principles used in divorce. Relationship duration, shared finances, and children cannot retroactively transform a non-marriage into a legally protected union. Void marriages represent a flawed attempt that still allows for financial relief, while non-marriages represent a procedural failure that leaves clients financially exposed. A practitioner's ultimate responsibility is to trace the relationship history, checking the district registry office notice, the timelines, and the specific formalities of the ceremony. Strict adherence to civil preliminaries establishes the legal foundation required to secure the financial rights of modern families.